Hi, this is Katie Toole with Garden Plain High School, and my topic for my presentation is student search and seizure. And this topic is important to our district because as administrators, we have the duty to protect all students and to provide a safe learning environment. And at that time, what that means is we will possibly have to conduct student searches, and we need to be compliant with all legal guidelines. So let's find out a little bit more about that. First of all, we need to be aware of the Fourth Amendment to the Constitution, which states the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. So the main question for educators is, are students in schools covered by the Fourth Amendment? And the answer to this is yes, to some extent, except the school coverage of the Fourth Amendment is quite different than any other legal or criminal coverage for citizens. In schools, the reasonableness of the search and individualized suspicion are the main issues in order to be compliant with the Fourth Amendment. So administrators can ask themselves some questions in regards to reasonableness. First of all, what is the reasonable suspicion? What are they trying to find? And number two, if there was an informant, is the informant credible and known? Anonymous informants are not considered reliable or credible in the court system. Secondly, individualized suspicion. It's unlawful to do sweep searches of all students in hopes of finding evidence of contraband. Administrators can ask themselves this question about individualized suspicion. First of all, what's the context of the situation? They also need to take into account the age and history or record of behaviors of a student, along with the safety of all students before a search is initiated. It is our job to keep all students safe, so it's necessary to look at what the effects may be if we do have a search and if we do not. There are several court cases regarding student search and seizure. First of all, New Jersey versus TLO is considered to be a huge case in 1985. This case found that searches by school officials are governed by the Fourth Amendment but are not held to the same standard as a criminal case. Officials are only required to have a probable chance of finding evidence of wrongdoing to proceed with the search. Secondly, Safford versus Redding in 2009. The court system found that the Arizona school officials went too far in strip searching a 13-year-old student who they believed might have provided ibuprofen to another student. Given the intrusiveness of the search and the relatively low threat posed, the search was unreasonable and a violation of the Fourth Amendment. This case really found that administrators have to be confident in what they're looking for and also use common sense. If we're talking about something of relatively low threat, such as searching for ibuprofen, is it necessary to conduct a strip search? And this court case found that it is not. Third, Desolate versus Clearview Regional Board of Education in 1994 found that searches of student book bags while on a field trip are constitutional since parents and students were notified prior to the searches. The notification piece is huge. If parents and students are notified in advance, then there's no reason for them not to comply, and that was a pretty cut and dry case. So what can be searched? As school administrators, we need to know what our realm is. What can we look at, what can we not? And obviously student desks and lockers. If there is reasonable suspicion, the desks and lockers can be searched. These items are owned by the school district, so therefore it is easier to conduct a search of these. The only ramifications is that the student and at least one other school personnel member must be present during the search with the administrator. Secondly, student automobiles. If the automobile is parked on school property, it is subject to a search if reasonable suspicion exists. If it is not parked on school property, law enforcement officers must secure permission or a warrant to search the vehicle. And if anything is found of criminal content, that is then turned over to the law enforcement agencies for that to be handled in criminal court. Book bags, although these are more personal, since they're owned by the student, carried by the student, this is considered more intrusive than searching a locker or a desk. But book bags may be searched if reasonable suspicion exists and if administrators believe that the safety of students may be compromised. Personal searches, otherwise known as strip searches, are highly controversial, and unless the safety of other students is at risk, personal searches of students are strongly discouraged. If a personal search must take place, two staff members of the same gender as the student must conduct the search. The student must be given privacy and alternate clothing to change into. Isolating the student and contacting parents and legal counsel is strongly advised before conducting a search. And truly, a personal search should be a last resort option only for school administrators. So what is illegal? Any arbitrary searches, any trying to look for contraband or look for content without having reasonable cause. If an administrator just arbitrarily walks up to a student and says, "Show me your book bag, let me go through it," that is considered illegal. And secondly, any mass shakedowns. So going for all students, searching all students at one time, these are considered illegal if there's not reasonable cause to do that. So there's two connections to the ISLIC standards. For standard number 3, it states that an education leader promotes the success of every student by ensuring management of the organization, operation, and resources for a safe, efficient, and effective learning environment. And this means that you have to promote and protect the welfare and safety of staff and students. And obviously, if there is an issue involving safety, then by all means, search and seizure may be appropriate. Once again, we as administrators have to protect our students and our staff. And if anything is going to compromise that, then it's our duty to go ahead and conduct a search and seizure. And standard number 5 states an education leader promotes the success of every student by acting with integrity, fairness, and in an ethical manner. And by doing so, we have to safeguard the values of democracy, equity, and diversity. And what this means is we as educators, we have to follow the ethics of the law. We have to think about the amendments and the Constitution and what that means in our school system. And we need to treat students fairly and give them the opportunity for due process if needed. Here are my references. I did use the textbook from Essex and also 2 websites that I found. They were awesome websites. Exploring Constitutional Conflicts, and then the Missouri Department of Elementary and Secondary Ed has a fabulous document online. I hope you've learned a lot about search and seizure, and hopefully you can use this in your school. Have a great day.